And welcome back to Talking Law TV, and we're here with Doug and Richard.
Hello.
How you doing?
Pretty good.
Good, Michael. Thanks.
Good. And we're going to talk about contributory negligence. And last week we talked about assumption of risk. So how does this work with that?
And there is a big difference. In the intro to the show, we say if you've been injured through no fault of your own, we need to look at that issue in a personal injury case, but that's pretty close to contributory negligence, isn't it, Richard?
Sure, and I think what we were kind of getting at is what that refers to is if you are at fault for your injury at all, you could not recover. That was the old law under what was called contributory negligence. Well, since that time, Georgia has kind of evolved, the courts have evolved, the legislature has evolved, and they've kind of intermingled contributory negligence with what today is called comparative negligence. And what all that boils down to is, as long as you are not more than 50% liable for your injuries, you can possibly recover. And that's the whole gist of comparative negligence.
Or even equal, 50-50. If
Yes.
you're 50% at fault and the other party is 50% at fault, you get nothing. What Richard's talking about in the old days, if you were just the tiniest bit at fault yourself and the other party was really responsible, you'd get nothing under contributory negligence. But we follow the comparative negligence rule, and that is as long as you're less than 50%, you can recover. It'll just affect your judgment.
We'll take this back to our bungee jumper example. So if they put the harness on you and you think it's too tight and loosen it a notch.
Or several notches.
Or several notches.
Yes, then absolutely. And that leads to a good question of where all this rolls in is what was the proximate cause of your injury? So if nothing was negligent from that bungee jumping example, except for you loosening it, then you were the proximate cause of your injury and you can't recover. Now, if you loosening it made it, I guess, worse, and there was negligence on behalf of the bungee company, then it just works as comparative of how much did you cause the accident versus how much did they.
That could be really tricky issues because in the bungee jumping example, if the guy that's putting you over the bridge, if he has inspected you and you're snug and he's okay with the equipment and all its adjustments, and then he turns his back and you loosen it too much, if that's the reason you fell out of the harness, then that's your fault, not his. However, let's say the standard, like a jump master, when I was in the 82nd Airborne as a jump master, I was responsible for that jumper up to the point he went out the door. So I had a duty to at least scan his equipment, make sure everything was okay. Maybe that bungee master has to examine him one last time just before he goes over, and he should have seen that it was too slack at that point. So maybe he would share in some responsibility. But these can be very fine issues of fact.
How does that work with a car accident?
Well, and I guess the biggest example would be, as you know, we've had a lot of rainy weather. So if you're speeding down the road and then someone, hits you because of their negligence, well, by the fact of you speeding down the road, you could be partly negligent and partly causing that car wreck. And then it works in who was more at fault, how do we determine the percentages of who was at fault more, and issues like that.
One of the more common things that I see when folks come in with just a traffic ticket, maybe no serious injury, they have a ticket for failing to yield. They came out of a driveway and you have a duty to yield to traffic coming on, but there's an accident. 9 times out of 10, that driver will say, I looked, there was nothing there. He must have been doing 100 miles an hour or something. Well, you still have a duty to make sure that the 100-mile-an-hour guy goes by safely. So that's on the failure to yield side of it. The civil side of it, there may be comparative negligence between the two parties, so it could affect the civil issues.
So could you recover in that case?
I think you could.
So if the person did look left, look right, look left again, pulled out, and the person was like going twice the speed limit.
And is this a great country or what? We also have something called the last clear chance. Tell us about that.
Well, actually, the last clear chance is another defense tactic, I guess, to try to prevent your recovery. To say that you, as the injured party, had the last clear chance to avoid the other person's negligence. And that's where kind of you look in both ways. Did you see that car speeding and decide to pull out in its pathway? That's where the last clear chance is a prime example of coming in. And it's like you said, you know, you have to have someone take a look at the facts and address these issues that knows what they're looking for, because it is a factual determination. It's ultimately up to the judge on who, or I'm sorry, the jury on who would decide the percentages of who's at fault.
So that's who's going to decide who shares the blame?
That, and with last clear chance, it's a complete bar.
Yeah,
right?
Absolutely. If the tortfeasor or the defendant or the person that was originally at fault could show that you had an opportunity to avoid them and you still got in their path, then yes, that could be a complete bar and you may not recover.
One of the easy examples would be, let's say that we're representing somebody that was going down Dean Forest Road and somebody pulled out in front of them. So they have failed to yield. But let's say that my client who's driving down the road is at that moment not looking, he's texting. If he was looking, he could have just moved over a little bit. So he had the last clear chance. He'd recover nothing as a complete defense.
Well, how does a lawyer look at this issue when it's time to choose or not take a case?
Very carefully.
Yeah, you have to look at all the facts, and the biggest thing I can say is that if you hire a lawyer, you need to get all your facts out there. You need to let the lawyer know everything, and the lawyer can do his own investigating and try to determine, you know, what in his opinion the issues are and where they feel like the assumption of the risk may come in or the contributory negligence. And you just have to weigh all those things.
So the way it sorts out is you go to trial and you try to convince a jury that your own client was no more than, if anything, no more than 49% negligent compared to the other party, 51% or 50.1, as long as it's not equal or more on my client's behalf. So then the jury goes and deliberates. They decide, well, who was at fault and how much by each one, and it affects the judgment that's returned.
Now, is this the kind of case that would more than likely be settled? Or is this one you want to put in front of a jury?
And I would say settled. I mean, I think the majority of cases settle, but the thing is, these are all the facts that lead towards a settlement. As you know, when you go before a jury, nobody knows what's going to happen. At least with the settlement, you can lay all your facts out to your client and say, hey, here's what the insurance company's claiming. Here's our position, but we're not going to know how 12 people are going to rule on this factual situation.
And sometimes it's the grown-up version of did to, did not, did to, did
Well,
not.
is this kind of situation where you try to bracket a settlement? I mean, you have a dollar number in mind?
Absolutely. I think that's where you take the goods and the bads of your case, and you put a dollar amount as if everything went your way, and you put a dollar amount as if nothing went your way, and that's kind of the range you work in, and to possibly get a settlement, you know, somewhere in that stream.
So Michael, let me ask you a question. If you don't have a seatbelt on and somebody pulls in front of you, the fact you're not wearing your seatbelt, it's required by law, right?
Correct.
The fact you're not wearing your seatbelt, should that reduce your recovery? Should you be contributorily or comparatively negligent for not wearing your seatbelt? Because that lets you go through the windshield? What do you think?
I would think I would be partially at fault.
And you were.
Yeah.
But what does our law say?
The statute clearly says they can't hold that against you. You can't diminish your damages because you weren't wearing your seatbelt.
Just a great country or what?
Yeah, we'll talk more about it another time. And we'll be back with Gene Brooks and lung injuries right after this.
But wear your seatbelts.